or judgment, writing.
We have two Mr. Jindals with us, Ekta, today.
Yes, we do. So Mr. Puneet Jindal is a senior advocate with the Punjab and Haryana High Court. So he is going to be around and he'll give the vote of thanks at the end. And Vishnu is around as well. So he's again there from Webnyai.
I'm also appearing on behalf of Webnyai. I'm giving vote of thanks on behalf of Webnyai only.
Nice to meet you, Mr. Jindal.
Welcome, Ekta.
The hell, should we begin or wait for a couple of minutes more for people to join?
Start, Neha. We start. I think we already have about 50 participants.
Yes, we have.
So
Yes,
Neha,
ma'am. Yes, so we can start.
Great. Okay. So good evening, ladies and gentlemen. A very, very warm welcome to each one of you for today's webinar on the Draft Mediation Bill 2021, which is Hopes and Concerns. I am delighted and my honor to welcome our panelists for today's discussion. Honorable Justice Joseph Kurian, retired Justice of the Supreme Court of India. Mr. Sriram Panchu, esteemed mediator with CMC. He is a senior advocate at the founder of Concord Mediation. Mr. A.S. Chandok, senior advocate and president of Madhyam Council for Mediation and Conflict Resolution. Mr. Francis Go, partner at Harry Ellis Partnership and principal mediator at Singapore Mediation Center. And our moderator for the evening, Ms. Ekta Bahel, senior mediator with the CMC, partner with Samvad Partners. On behalf of CMC, I thank you for taking time from your busy schedule today to deliberate on the draft mediation bill for the benefit of our members. We are delighted to have all of you among us. By way of a short introduction, the Center for Mediation Conciliation provides a much needed neutral institutional platform for resolving commercial disputes and wishes to promote an efficient, sustainable and solution-oriented dispute resolution process for resolving commercial disputes. As a mediation center, CMC, or the Center for Mediation and Conciliation as is known, is associated with the High Court of Bombay and the City and Sessions Court of Mumbai, and is recognized by the Government of India, Ministries of Law and Justice, and the Micro, Small and Medium Enterprises. The Bombay Chamber of Commerce Industry, which is one of India's oldest operational chamber, has always been quick to assist corporate and industrials in all matters and have been ahead of our times when we bet on mediation to be a game changer. We are of the view that in today's fast-paced world, mediation is a must for settling dispute as we believe in its mantra, cheaper, better, faster. I see that like our panelists, our participants are also represent a variety of fields. We have some advocates. We wish to gauge how mediation might expand their scope of skills and work. We have students who may at the precipice of witnessing a mammoth change in the way dispute resolution comes about as we go along, and corporate officials who might be interested in learning more about this concept. I hope this session will allow for a comprehensive discussion and addresses as many of our hopes and concerns as possible. I wish to end by acknowledging that everyone on this panel has been on the forefront of mainstream mediation. I would go as far as to say that mediation has been something of a people's movement in India, with organizations like ours trying to create an ecosystem conducive to the progress by providing the infrastructure and expertise. It is my sincere hope that this bill provides an acceptability to the process, removing the hesitancy that the corporates and common man face without minimizing its potential benefits. Thank you once again, and looking forward to an enlightening and interactive session. I would now like to hand over to Ms. Ekta to take this forward. Thank you.
Thank you so much, Mr. Khosla. In fact, for mediation, these are very exciting times. We had the Singapore Convention that happened in 2019. And in just about 2 years, we are now talking about a new draft bill, which is in fact going to be tabled before the Parliament in this very winter session and hopefully next week. So very soon we probably get to see what the Parliament thinks of the draft bill that is there before them. But but before we get into that, it was open for public consultation. There have been mixed reviews about the entire legislation. There's the good and there's probably not so good. I wouldn't like to call it bad, because there are always works of improvement. We've had arbitration that came in the form of 1940 Act, then we saw 96 Act. And even today we see continuous evolvements happening in the statute itself, basically because of their party's function, the judiciary, and of course the current market reality. So we'll just get into it. And I would like to start with the mediation bill at its fundamental, and we go into the preamble, because which sets out the tone of what the law is supposed to be. So the preamble actually talks about the law being a comprehensive, uniform legislation for mediation to deal with anything to do with mediation resolution, whether it's accreditation, registration, community mediation, whether it's commercial or otherwise. It has a chapter on online mediation, on community mediation. But if you look at how the structure of the law is, and especially if you factor in how Section 61 reads, which goes on to say that it is an addition to and not a derogation of any other law that provides for mediation. My question to Mr. Panchu is that how, in your view, do you think it's really truly a comprehensive legislation? And do you see any challenges to the way it's drafted? And what are the, where do you think it has actually covered things, rather well, and where it's probably a work in progress and needs more improvement?
Thank you, Ekta, and good evening to everyone. I have mixed feelings about this bill. On the one hand, I'm glad that there is a statute focusing on mediation instead of finding scattered references, in multiple statutes. I'm glad that this confusion between mediation and conciliation has been removed. We've been battling, different theories about is it the same, is it different, how different, etc. But now that's been removed. We have to use the term mediation, and conciliation is equated with it. So I'm glad that's happened. I'm glad that the concept of pre-litigation mediation is embedded in this act. And I see that as the driver for the growth of professional mediation in India. It is the compulsion to mediate before you go to court that I think is really going to make people come to mediation tables. So I see that as very, very important. this act is also important because it incorporates what we need to do to live up to our obligations in the Singapore Convention. And therefore to satisfy, business houses that they will have the benefit of the Singapore Convention across the world wherever the convention operates. So it's important for that. It's important because we have given mediation the status of a judgment or order or decree of court. It's important because it recognizes online mediation. And when it recognizes, service providers and mediation institutes for training, there is a nod towards community mediation. So all these things are good. But there are three disaster areas. One is clubbing international mediation with domestic mediation. I mean, on the face of it, this is something you cannot do. You cannot say domestic mediation is where it is conducted in India, parties are here, etc., and includes international mediation. I mean, on the face of it, these are two different things. And because it has done that, we run into a difficulty which we pointed it out to government, but I don't know. I mean, we don't know, where they are with it. And that is this: that if you do an international commercial mediation in India, right, and you have a successful result, then under Section 28 of this Act, that agreement has the force of a judgment or order or decree of court. But when you go to the Singapore Convention, under that convention, it does not apply to the agreement which has the status of a judgment or decree of court. Which means what? That if you are in an international commercial mediation, a simple trick then is not to do it in India. Because if you do it in India, you will not have the Singapore Convention as your ally to help you with enforcement. So you will do it outside. So all the grandiose hopes of government that we will make India a dispute resolution hub, etc., is clean out of the window. And I seriously don't know that even after repeated explanations whether Ministry of Law has got this clear. We will know when that bill comes. But if that bill still has this clause, then that's not speaking well of draftsmanship capacity. Number two disaster is the council. I mean, this is a professional body. It's like lawyers. And we hope to make mediation a profession. Now you look at the council, and there is one person who has to be a judge of a court, of the Supreme Court or the High Court. That's fine. We wanted that. But the two others are supposed to be full-time members who are experts in ADR. For all you know, that could just be arbitration. And once you say full-time member, that means that person is really not an active practitioner. And there is no place for mediators in the council. Now, how do you have a professional regulatory body with no members of the profession? And this is so vastly different from the bill which a senior committee of mediators sat together for several months, drafted, gave to the Supreme Court, which put its own seal of approval on it and sent it to government. So different from that. I mean, I look at this council and I think this is a government regulatory body. Like how you will regulate a port or airport or something like that. This is not the way you treat a professional body. And my third problem is with the list of exclusions. You frame them so wide, if there is an allegation of fraud, it can't go to mediation. I mean, what nonsense is this? Every other case, people say fraud, forgery, coercion, etc. You want to throw every charge in the world against the other. You bring them to the mediation table and they will apologize, say, I'm sorry, I said that, I'm sorry, etc. And they'll completely ignore that and settle. So just to say that there are, allegations and therefore you can't even mediate makes no sense. Similarly, claims against minors, deities, people of unsound mind. You don't have to ban those cases. All you have to do is to say, in these cases, the mediation will take effect only after the court has certified that it is in the interest of the minor. The CPC already has that provision. So none of these exclusions, I don't want to take much time, but none of these exclusions really merit it, except for serious, criminal acts and cases which you can get a decree only from the court. Otherwise, anything that can potentially be settled should go to mediation, and it's the parties there to decide whether to settle or not. But there's this block which has now been placed, and it also says this list is indicative and not exhaustive. I mean, indicative means what? Tomorrow, anybody will say, oh, this was just indicative. Mine really, is similar to that. So I also don't think this. So as I said, 3 serious disasters with a lot of good things. And that's my take on this mediation.
Thank you, Mr. Panchu. My next question is to Justice Kurian and to Mr. Chandyok. So I will go with Justice Kurian first. Now, leading from where Mr. Panchu was talking about, you have the list of exclusions. So, how do you look at it? Can it be challenged? Then you have the issues of, is it if it's Singapore Convention, is it enforceable, not enforceable as a decree? Whereas in terms of a domestic mediation, you're looking at a decree. Now, the heart of mediation or a mediated settlement agreement, and if you're looking at giving it the teeth that it requires, is the enforceability of it without parties picking on technical grounds to overturn a mediated settlement agreement. Now, if you look at the bill itself, it puts both the domestic mediation as well as the international mediation under Singapore Convention on the grounds that they can be overturned on different footings. Now, Justice Kurian, if it was something like this that would come to before you, or even if you think as a litigator, how effective do you think mediation settlements would be if there were available grounds of mediation such as those? Because we've actually seen the jurisprudence of when arbitration awards could be challenged, and it's taken us 25 years to sort of get to a place where the grounds are gradually getting narrower. But if you open the door wide for mediation, especially given how mediation works and how different it is from arbitration, what is your take on the mediation bill, keeping in mind the enforceability of the mediation settlement agreement?
Thank you, Ekta. Our good friend Sriram has given us a very, in a way, I should say, an exhaustive list of the problems that have been created in the bill, which probably the drafting committee did not even think of. If you remember the Consumer Protection Act, when that legislation was introduced, it was a wonderful legislation. But it took so many years to settle that who is a consumer and what is a dispute. I think the same is going to be the fate of this legislation as well, unless we define clearly as to what is this meant for. After all, we should realize that this is a mechanism whereby the disputes of the people are settled by the people. It is very clear, very simple. Disputes of the people are settled by the people. So we are going to professionalize it. And we are going to have some standards fixed through this legislation. This is all what is sought to be done. And now, if you're going to define this domestic and international, see, in these changed times, when we think about online mediation, where are we going to decide that it is international or domestic? Where is the seat? And what difference does it make as to the see to the parties, one Indian, except that one may be a citizen of this country, one may be a citizen of another country, except that, what else could be the difference? And even with that also, the parties having come to India and entered into what they call a contract or entered into an arrangement, etc., meet a family. And unfortunately, this family is out of international dispute, because international disputes resolution is, the mediation is only for commercial disputes. It's very strange. It is limited to commercial disputes. They say, if you see the types of cases that we see in all the courts, majority of the people, particularly the matrimonial and custody of children, all are, people involving, the couple working outside. Some of them have become citizens of other country. Some are otherwise born citizens of those country and, entered into life situations here, etc., etc. And this living to their concepts. All those things, if you are just going to take away from the international mediation, only say that it is only the what they call commercial disputes alone will come under international, and commercial will come only in national or domestic. Why should there be a differentiation? Now, coming to the grounds, because the pointed question is on probably this aspect will be discussed later also. On the grounds, see, you cannot attack an arbitration, you cannot have the same grounds as you attack an arbitration award, because it is an adjudicatory process, an award in an adjudicatory process. There, the participatory level and participatory role, both are different. Whereas in mediation, it is your court and you are the people who decide. And therefore, it should not be over-regulated. If you are going to have, say, like, the one ground suggested is, gross impropriety. What do you mean by gross impropriety? I can understand the impersonation. How can there be impersonation? Because those two sides are there, no? You have to identify yourself, because you are entering to a dispute resolution through mediation of a non-dispute. It's not something unknown. It's not as if you are not known each other earlier. You know the parties, So maybe still then, the representative could be impersonating. Possible, I can understand. But gross impropriety, and of course, the fraud is always there, and opposed to public policy. They're the four grounds suggested. But if it is over-regulated, then the whole purpose of being an ADR will be defeated, because we wanted to decongest the court, we wanted to ease the burden of the litigants. Both these things will go, because it becomes a simple appellate jurisdictionary challenge thereafter immediately. That's the fate now, unfortunately, of arbitration. 16, 17, and 9, 11, 16, 17, 34, 37. See, we have lost the credibility of that dispute. Unfortunately, pardon me if I say that also, because I'm an arbitrator myself now. After having retired 3 years, I've been doing that also. And of course, mediation. But see, the fate of arbitration awards goes into the challenge in the appeal, and thereafter, it goes to the Supreme Court, etc. Nobody's in a position, particularly international. They have lost faith in that system. Almost. That is why, they all go for institutional arbitrations outside. They prefer London, they prefer Paris, they prefer Singapore. That is the situation now. So therefore, to me, I must say it should not be over-regulated at all. The way it has been presented now, it is over-regulated and is bound to succumb to a challenge on the ground of being irrational, and which does not serve its purpose.
Thank you so much, Justice Kurian. Mr. Chandiv, coming to you now. When we talk about, Justice Kurian was saying we're looking at fraud, we're looking at gross impropriety, we're looking at impersonation. Now, if you look at a mediation, and unlike an arbitration where you have one party, an arbitrator who actually adjudicates a matter, in a mediation, parties sort of settle it up. But when we look at the bill, the question of making an appeal is subject to a limitation period. So if you want to appeal a mediated settlement agreement, there's a fixed time period that's given. Now, given the nature of mediation and the grounds for challenge, how would you perceive this limitation period? That's one question I'd like to ask you. The other one is, in fact, Mr. Panchu actually said this. He said pre-litigation mediation is what is going to really promote mediation. We saw something similar coming up with the Commercial Courts Act when they introduced 12A. So, do you foresee challenges with that, given your experience? Do you think that the Act is adequate? Do we need anything further to strengthen this pre-litigation mediation process? And just a given line, we've had a couple of decisions of various courts in the recent past, which have actually said that pre-litigation mediation is not mandatory as well. So,
well, thank you, Ekta, but I must say that I think the very purpose of having a consolidated mediation was that there was too many diversity all around, and we wanted to bring it at one place so that there is uniformity, at least for a structured mediation. That's the first part. And I think, therefore, my first objection is to the word act. It can't be an act, it has to be a code, because it amends many acts in the schedule, first part. And we have seen this earlier happening, where we amended other laws, so it has to be a code, it can't be an act, first part. The second part, your pointed question to me on limitation, if I'm having a registration also, I'm also having a depository to deposit that mediation settlement. It is not necessary that I may have a dispute which may come in the next 3 months. My first objection is you can't have a challenge, because as I think Mr. Shriram Panchu and my lord said, that this is empowering people to come to a resolution. You are empowering those, you're only facilitator. Parties are settling this matter. Now, if parties are settling this matter, then where is the question of fraud? And please see Section 17 of the Contract Act. It says if my intent was to make a promise, not to actually implement it, is fraudulent. So if I made a promise in the mediation settlement, which I didn't intend to actually implement it, is fraud. Therefore, it is set aside. So where is the question of it may, if I'm depository, maybe it may be a running contract for many years. Electricity, for that matter, in joint ventures, for that matter, technical know-how. How will you be able to say that within 3 months I must challenge that? So my first part is the bill should not consider. It's a different thing to say a mediation settlement will not be implemented, or a court will not implement it on some grounds, as provided in the convention also. That's different. It's like what we have under the Arbitration Act. But why are we saying that the mediation settlement itself can be challenged? Then the very purpose of giving that judicial settlement in terms of Order 23, Rule 3, all that is gone. We have diluted everything in the mediation statute. We can't do that. So a mediation settlement is binding on people. In fact, I have a view, and I think Shriram Panchu would bear me out. I've been saying that like we have a doctrine of lis pendens, we should in fact say under 12A now that wherever there is a pre-litigation mediation, status quo will automatically be maintained. You will not change the status quo. That should be the statutory provision in law. It can't be like this that we have to, and the courts are taken a view that it's not mandatory. Then the words are used, shall, unless it exhausts the remedy of mediation. It can't go to file a suit, but we file an application for interlocutory and the court allows it. So we need to come very heavily on this position. This mediation bill was meant, or an act or a code is important in order to ensure that all that we provided, that somewhere we say mediator will be appointed by the government, somewhere we say somebody appointed, all that things come to an end, and it's less regulated. It has to be regulated, as Shriram Panchu actually said. The professionals, they must regulate themselves. And please tell me, we started this amendment in 2002. We have come in 2021. The Supreme Court in 2010 said, please amend the definition in Section 89. We didn't do anything. And today, all those mediators, I'm not talking about myself, or I'm not even talking about Shriram Panchu or my Lord Justice Joseph. I'm talking about all those mediators, right from Jammu and Kashmir till Kanyakumari, who are already mediators, must get them registered. So the registration may take time, council itself may take time. We have seen how Section 1A has not been implemented till date of the Arbitration Act. So the council must be of the professionals who are actually know what mediation is, what should be its regulations, how do we want to implement it, who should be, and there's no transitory period at all. We are not saying, we have done this in IBC. We never had a resolution professional earlier. We said if you qualify with these qualifications, you become a resolution professional, till the time we are able to make something more stringent. Therefore, there has to be something in it. There's nothing like this here. All those mediators who Mr. Shriram Panchu and all of people from have given, MCPC has given. Let's not talk individual. MCP has trained people over the years. All those mediators go down the drain because till they get registered, they can't do mediation. And if you are asking it to become a profession, then if you start making mediation settlements to be part of a process adjudicatory, that I can go and challenge it on fraud, on impropriety, impersonation, then what is left then? What is mediation settlement for? Then I don't think I need to take this bill. The disasters pointed out by Mr. Shriram Panchu and the points raised by Mr. Joseph, I think are much more disastrous than the advantages that we find today. Because it has taken us 12 years. DC 1996 Act, Ekta you just now mentioned. We brought that amendment in Arbitration Act now in 2015, where we brought Section 9 out of the previous Part 1. So we are again bringing it back. We have brought, as Shriram Panchu rightly said, we brought both of them again together at one place. So why are we not able to ask our professionals who have done mediation over these years, who actually applied their mind for a long time? Please call them, ask them to look at it, advise you. If there is something so serious about it, I'm sure. And I ask myself, if something has been recommended by the Supreme Court, you thought the Supreme Court was not looking at it at all? At least you should have given something to that, but nothing, you changed the whole thing. So the mediation bill submitted to the government, sent to the government, I will not even say word submitted, by the Honorable Supreme Court, should have been adopted if there was something that the government wanted or the legislature wanted to amend it. Yes, it was appropriate for them to send it back to the Supreme Court for reconsideration. And therefore, to me, the disasters are much higher than advantages that we have. Yes, that's a great advantage that today you think mediation should have a statute. That's all.
Thank you so much, Mr. Chandyok. Now, Francis, coming to you. Singapore actually started its formalization process of mediation. 2017, you had a Mediation Act that came about. A year later, we had discussions on the Singapore Convention, and it was eventually signed in 2019. Singapore was actually one of the first countries to not just sign it, but also ratify it. So, given the parallels of now we are entering into a stage where we are looking at a Mediation Act, how did Singapore sort of transition from a domestic legislation now to look at incorporating the Singapore Convention to make it to look at enforceability of mediated settlements? And you also heard concerns that Mr. Pancho, Justice Kurian, and Mr. Chandyok also mentioned with respect to the current bill. So, in your experience, are there similar challenges that are you facing in Singapore, and how, if not, then how have you dealt with things differently?
Right. Thank you, and it's an honor to be part of this panel. And to your question, Singapore's journey or love affair with mediation actually started in the 1990s. And we had a lot of twists and turns and bumps. There was a twin track of court annex mediation, as well as private mediation led by the Singapore Mediation Centre. But there was concerns about legitimacy and enforceability, and so there was a need for comprehensive legislation. And that came in the form of the Mediation Act 2017. It purports to be a comprehensive legislation dealing with any mediation that takes place in Singapore or is governed by Singapore law. But it has also the exclusionary words, such as if it is covered under any other statute, then that statute would apply. What we have experienced with this kind of a formula is that it allowed a comprehensive cushion, as it were, to clarify the law on mediation through this Mediation Act, and yet at the same time allow for subsidiary or umbrella or offshoot litigation to take place as the mediation scene developed. So now we have employment mediation, we have family mediation, we have intellectual property mediation, which are governed by their own processes and statutes. And then the laws that developed around the Mediation Act Why did we want this act? It is to ensure legitimacy. Prior to the act, when people talked about mediation, it was seen as a soft option. Litigation and arbitration are preferred. But now there is a Mediation Act, which provides for enforceability and which clarifies the law. Let me just do a quick survey. There's stay of court proceedings in favor of arbitration in Section 8. And in granting that stay, the court can also grant interim relief to preserve the rights of parties. There's restrictions on admissibility of mediation communication. That's the term used in the Act. And that deals with confidentiality at its various nuance levels. Parties can opt to have their mediation agreement recorded as an order of court with the consent of all parties and provided other criteria are met. So it's not automatic that it will be recognized as a court judgment. And what this has done is it's provided legitimacy, enforceability, and clarity to our laws on mediation. So fast forward to the Singapore Mediation Convention. We've got that comprehensive legislation, and our legislature was faced with what to do now to fulfill our responsibilities under the Singapore Convention on Mediation. The decision was made to actually have a standalone act. From our experience, a standalone act allows clarity between domestic or any other type of mediation as compared to the convention mediation and the international commercial mediations. It allows the international parties, if they were going to look for what they have to comply with for their international mediations, they look at one act, which is the Singapore Convention on Mediation Act, rather than worrying about having to navigate through the various domestic aspects. But even then, there was harmony between the two, because when you've got a mediated international agreement, you can either choose to go by the Convention on Mediation Act, but if you don't register it or apply for registration under that act, you still have the option of proceeding under the Singapore Mediation Act 2017. So it's a very interesting interplay. We are looking to see how this will be taken up and played up in the years ahead as more countries all come together with the Singapore Convention on Mediation. So that's my contribution tonight.
Thank you so much, Francis. Good to hear, the fact that, in fact, what Sriram was actually saying earlier, that, do we need to combine everything and put them in one bucket? Do we need to talk about international and domestic under the same legislation? It's nice to hear another view that, how you can actually look at bifurcating them two in different buckets and then create harmony between the two. But as you're right, everything is too new. We have to see how this entire thing plays out. Now, coming to, again, structure of mediation bill. Mediation bill is actually put everything in 4 large parts. You have domestic, you have community mediation, you have international commercial mediation, and then you have miscellaneous. And we have online dispute resolution, which is actually put into the bucket of domestic mediation. And, which was also mentioned earlier, that how can you online, as just Kurin said, where is jurisdiction, etc. So you have a lot of other challenges. But there are a couple of other aspects of mediation which typically take up significant. And Francis, you mentioned that, you've got workplace and family mediation is dealt under separate legislations as well. Now, on one hand, we're talking about our mediation bill being a comprehensive legislation, but we don't see things like family mediation or workplace mediation featuring part of it. And maybe it's included as part of your domestic mediation. But then we have for community mediation, you have a smaller chapter on it. And then for ODR, we mention it differently. Now, do we need to, so the question is, and do we really need to have, different buckets for different kinds of mediation? And then why do we limit it only to ODR and community? Or should we have everything clearly spelled out when you're looking at family and even say, workplace mediation? And especially when you're talking about family mediations, you again have international mediations that could crop up, because matrimonial disputes are no longer limited to domestic shores anymore. You have international mediations as well, or international disputes as well. So I'd like to hear, the view of the panelists, and we can start with you, Mr. Panchu, and then look at Mr. Kurian and then Mr. Chandyok and then Francis, in terms of quickly what your views are on that.
Yeah, I think principally what this act does is to focus on, who's a mediator. Trained by whom, and that's an important area for this act. Frankly, see, you have family mediation, you have industrial disputes. Now, to me, it's not so important whether they stay in different acts or come in this. We've operated for quite some time with having mediation in the family courts, and that works quite well. So I don't think that's the issue. I think the issue is that we haven't got this act right. And because we haven't got it right, I think we're going to, quite frankly, ruin mediation wherever else it exists. My point is, get the fundamentals right here. If after that you want to add one schedule for family, one schedule for court annexed. In fact, in our draft, we suggested one chapter for court annexed mediation to be statutory, and that's been lopped off. Court annexed, industrial, family, commercial does not have to be international commercial. There are so many other commercial disputes, international disputes, which are non-commercial. You bring them in. So either you do it by linkages, or you bring in everything under this act. I'm fine with either. But if this act is your baseline act of mediation, then for God's sake, get this right first. If you don't get this right, or I'm saying I'm saying this in a lighter vein, so please don't think I'm being too harsh. How many of you remember this old rhyme? It says, I'm the parliamentary draftsman. I make the country's laws, and of half the country's litigation, I'm undoubtedly the cause. So, yeah, so that's my take. It is not difficult to neatly bring in all forms of mediation and connect them and implement them. It's not difficult at all. But if you have a corrosive base, which doesn't stay, I think that is let's recognize where the problem is. Yeah, thank you.
Thank you, Mr. Panchu. Justice Kurian.
Yes, Singapore, as Mr. Francis rightly said, after prolonged experimenting with experiments with the various forms, etc., they put into different buckets, etc. For us, it's too early for us now to compartmentalize and make separate legislations. But still, I would say, we have conceived of a council, and the council should be left with this power to make regulations. So as Mr. Chandyok said, if it is a code, then, while making regulations, they can think of this sort of a compartmentalization of matrimonial, industrial, commercial, court annexed, etc., etc. But for us, India, to start with, I think it's better to have a comprehensive legislation to start with, but making it commercial and non-commercial, just two compartments. Even if it is court annexed, also it is commercial, non-commercial. And the advantage of court annexed mediation is different because there's some sort of an oversight by the court. That's a great advantage. For other institutional mediations, there may not be such an oversight. Therefore, subject-wise, it would be appropriate at this stage for India to make it commercial and non-commercial, and leave the rest to the arbitration council to take a call, and which should include. I would definitely endorse Mr. Panju and Chandyok that the council should have at least a couple of mediators there, because without whom only if ADR experts are there, and there could be even arbitrators, there will be conciliators, there could be retired people. There is no harm about it, but people who are actually in mediation and who have known and who have seen what is mediation, what is not mediation, should be there, so that it'll be we'll be in the position to take things forward. That's my view about it.
Chandyok?
I have already said, I think the question today is if the statute already, let's take Francis' opinion on view on that there were different legislation which provide for process. Therefore, they have already put that into place and recognized that. So that has to be harmonized. As I said, the Consumer Forum Act talks of a different mediation. Companies Act talks of a different mediation. Some other act talks of a different mediation. So mediation is only one process. There's no different processes. The legislature has made those distinctions. So the purpose of this act was to bring them together at one place. And today India has not signed the Hague Convention. And I see in the last 1.5 years, I see in fact, in the last 1.5 months, the Supreme Court itself has reversed its judgment on custody. I mean, cross-border situation. It has reversed its own judgment. They found that yes, it was wrong on their part to have given the custody to the child. Now, if they were to be mediated upon, maybe that joint parenting that we are looking at today, a concept which is internationally today recognized, should we not look at that part into part of the mediation process? Mediator will facilitate that part where joint parenting for a child will take place. So in every statute, whether it's Consumer Protection Act, whether it's Companies Act, and look at creditors or debtors in a Companies Act, you're asking a company to be wound up, or you want a company to be restructured, or you want just an equitable ground to be thrown out the directors of board. Now, if that can't be mediated, then what else is to be mediated? I have not been able to follow. And please look at 138, for example, Negotiable Instruments Act, which is really a money decree. He has given you, he owes money to you, and therefore he has issued an instrument. Which instrument is negotiable instrument? And if I can sit down with him, take installments from him, I'm sure it will be mediated upon. The mediator will help us to do that. So for all these processes, if you are excluding, then what for are you making mediation at all? Therefore, today, in fact, the suggestion was that every dispute, and why are we missing panchayats? Why are we missing district courts? We have said court is a district court. Why should we not go to a sub-judge or a municipal court? He has all more disputes than anybody else has. So the court's definition itself is, to me, my humble way, that we should start from panchayat. Panchayat is part of the constitutional scheme today. We brought an amendment and brought panchayats into it. And please see the schedule that is given under this constitution, what all panchayat can do. So if those disputes can't be mediated upon, then I'm afraid the very purpose of thinking of a statute does not realize. I'm not wanting to be harsh on that. With Sriram Panchu said, 50% of the litigation is by the legislature. Today, to me, this statute is 100% litigation by the statute, not even 50% in terms of that point. So therefore, why are we increasing litigation? If the purpose is to bring peace and harmony in the society, if we reduce conflicts in the society, irrespective of what kind of dispute it is, then I must say the mediation should have said every dispute and conflict must go to mediation. That's where you will encourage mediation. And you are asking international community to come to India to be an international hub, then you must involve them into it. You must say, yes, you are entitled to come to India and these are the benefits for it. But if we are going to make it that in 3 months I can challenge it also, then no international community is going to come to India to have a mediation settlement. I'm sure about it. Because the settlement means a settlement by the parties. As I said earlier, it's party settlement. Mediator is only facilitating or helping him out. Therefore, if that is subject matter of challenge on these grounds, then what's the difference between adjudication and settlement? In fact, the grounds of adjudication in the Act today are much larger than what we have under Section 34 of the Arbitration Act. They're much larger. Therefore, all this, and fraud would mean the agreement is void. So if the agreement is void, then how will there be a limitation for it? Supposing I deduct that after 6 months that was void, or it's against law, then how do we do that? So consequently, the entire bill, to my mind, subject to, yes, of course, there are good things in it. We must retain them. I'm not saying no. But these are basics. If you want this profession to be a profession in this country, if you want youngsters to come into this profession, if you want actually the conflicts to be resolved, then you must bring the status to mediation of a professional who is able to felicitate people to resolve their conflicts one way or the other without wasting time, without going to court, and what else we can do. In a commercial litigation today, I don't know, courts have said it's may, but the statute uses the word shall in 12A. Therefore, mediation must become compulsory for people to resolve their disputes. If they can't do it, of course, court is always meant there. That's also part of the statute, part of the constitution, that subordinate courts right up to the Supreme Court is a statutory situation. It's a constitutional law. But if we are looking at process other than something to be resolved by parties themselves, then I think they must give the status mediation to a higher thing than what they've done in mediation.
Thank you, sir. Francis, since you already mentioned that in Singapore you've got workplace and family mediation under different sets of legislation, so I'll ask the question slightly differently. And when you're looking at what Mr. Panchu was saying, and the concern has largely risen out, we can always have it, but you need to have a mediation council, and because our law contemplates having a mediation council who can understand that, and then we have the composition of the council itself, which is a cause of concern for a lot of us here. Do you have similar challenges in Singapore, and do you have some sort of a body that looks at, or whether it's you call it a council or any other terminology, who oversees that entire mediation process and sort of enacts rules and is like a headmaster sitting around and telling people that this is how you need to be?
Okay, thank you for the question. I'll try to give as comprehensive an answer as I can, and I'll begin with the sentiment that has been expressed that we want to make peace. Mediation brings a very different type of dispute resolution mindset. Litigation and arbitration are adversarial and combative. The mediation dispute resolution mindset is collaborative, facilitative, and helping parties find a solution. So the conditions of men and the nature of disputes are so diverse. So in Singapore, I think we grappled with that, and in the end, we came to this kind of a landing, which I would summarize in this way. We adopted a comprehensive act that covers any mediation that took place in Singapore or was governed by Singapore laws. But we recognize that there may be processes and needs, for example, in employment, intellectual property, consumers, where the same spirit of collaborative, facilitative solution finding is there, but the processes and maybe the approach might be slightly different. Even mediation for us practitioners, we know that there's a whole spectrum. There's facilitative all the way to evaluative, and then there's therapeutic type of mediation. There's a whole spectrum. So what we opted for in Singapore, and it's still a learning process. We don't claim to have all the answers. We're just finding our way. But what the landing that we have is that we adopted a light touch. We went with definitions of what is mediation. It is helping parties to come to a settlement, led by a third party neutral with no power to make or impose a decision on the parties. That language is also found in the Singapore Convention on Mediation. So with that broad definition, we then let the processes take care of themselves, be it in consumer mediation, employment mediation, intellectual property mediation. And then the idea was that we would then be able to cover all that ground. But to your point about, do we have a council? No, we don't. In fact, we felt that the subject was so big and diverse that we actually have 4 bodies. All right. We have the Singapore Mediation Center, which was the first center that began the private mediation sector for us. That continues to remain with the training and empanelment of mediators and basically creating the baseline for mediation. We recently added the Singapore International Mediation Center, and as the name suggests, that's to take care of convention type mediation, promote international mediation. And then there is SIDRA, which is based out of the Singapore Management University, whereby they collaborate to be thought leaders about what mediation should be. And then we have something called SIMI, Singapore International Mediation Institute, which is partnered with the IMI, which is internationally recognized. The purpose here was to have an independent body in charge of accreditation, in charge of the professional development and progression of our mediators, which are benchmarked against a world standard. The idea here is that with this independence, there is then professionalism, and then that results in greater confidence. So the answer there would be, we feel that the subject was so big that we actually created 4 governing bodies or 4 leading bodies to help us lead the way. Is it the best? We're not sure. With how these bodies actually interact, collaborate, but I think the concept there was, as we grow the pie and as the pie gets bigger, mediation gains traction and it's good for everyone. So let's hope for the best. Thank you. Over to you.
Hector, can I ask one question to Mr. Francis? Yeah. Mr. Francis, since you said, it is facilitative, evaluative, and therapeutic, but does it not require some specialized knowledge on the part of the mediator per se? So like, the company, like say the insolvency, like matrimonial, like other corporates. So do you have any such sort of a mechanism whereby you always select the mediators in tune with their qualification rather than the technical qualification they possess for the field that they are to be engaged for mediation?
Thank you, Justice. That's a good question. Singapore has adopted a baseline that mediation is, a mediator is really like a person that manages the process, the communication among parties. So things like communication skills, empathy, awareness of culture, and the like, those are essential skills for the mediator. So that would be the baseline which any mediator worth his salt will be measured against. But then given that there are the various areas, there are certain mediators that gravitate, say, towards family type mediation. And they have specialized training which they can go for to talk about the psychology, to talk about the handling of children, and the sensitivity to manage emotions. And then there are the intellectual property type mediations, where perhaps knowledge of intellectual property would give confidence to the party that is appointing the mediator, because he says, he understands my language, but it is not an essential that you must have that specialized knowledge in order to mediate. Rather, the contrary is true. We believe that you need to have that mediator skills, that empathy, that cultural sensitivity, that communicativeness that will then qualify you to do this type of collaborative dispute resolution. And then certainly you advance and add on your skills. Hope that answers the question, Justice.
Yeah, I asked this question because, the mediator will have to see the legitimacy of the options involved in the process. So if he
Yes.
needs to know the legitimacy, he should have some such knowledge.
Yes. So, Justice, in Singapore, there is a practice also that's quite popular of co-mediation. So there's no single mediator, but you can pair a mediator who is strong in process with somebody who is strong in subject matter, but maybe more junior as a mediator. And they do this tag team in the mediations, and we've seen good success with that.
Ekta, may I come in?
Of course. I think this is great, because if you're having the panelists have a discussion on an issue, I think it's fruitful because we widen our perspectives, and that is one way we develop ourselves. So please, sir.
Yeah, I think what Francis was talking about, the way they do it in Singapore, and I've seen this over the years. And what I notice is that they all come together. The minister, the ministry, the judiciary, the chief justice, the organizations, the professionals, they are all operating on the same page. And it's remarkable to see. And I'm an outsider. I've seen this happening over the last, 20 years. The way they get together, formally, informally, they chart their path. They decide who's going to do what are the institutions we're going to create. And as Francis said, there is the domestic mediation, the international mediation, the research. And this one small country drove, the world for the Singapore Convention. That's a lesson which we just have not imbibed. We have sat on this act for about 8 months or more now. And we, the professionals who drafted, the first draft and gave it to the Supreme Court, do not know what is happening in the legislative department of the Government of India. Even the Supreme Court does not know. And this is, it's exactly the opposite of how it happens in Singapore. We operate in these silos, with diminished capacity, therefore. Singapore is a brilliant example of how you get your act together to do the things that are important and need to get done. We have a lot to learn from that. Congratulations, Francis. I really admire your country for the way it organizes things.
Thank you. Very kind words, but we are still learning. We have our own silos, our own challenges, but the cooperation of the stakeholders, and a big chunk of them are the practitioners. We took many years to convince them that mediation is the way to go. And I think we have just reached the tipping point in recent months, because in April next year, our new rules of court are coming out. The presumption of ADR that began in 2012 is now being enshrined as the values of the court system. And parties, lawyers are expected to advise their clients on ADR, in particular mediation, before they commence litigation. And that is mandated in our new act and the practice directions. on pain of costs if the judge feels that you have unreasonably refused amicable settlement. So it's taken us a long journey. The practitioners are still kicking and screaming about how their rice bowl is being taken away and how they are being forced into this alternative dispute resolution. So we are still learning. And I think it's a journey that all of us will have to embark on.
No, but Shriram Panchu, you'll bear with me. Singapore set an example, and I think the lead was given by none else but Chief Justice Menon himself.
Yeah.
He took upon himself first look at arbitration, then he has now taken upon himself intellectual property. You will find most of the intellectual property disputes going to Singapore. So therefore, if we are looking at that, then we should have gone that lesson through. And fortunately, for the Supreme Court should have, I don't know why can't Supreme Court so more to look at it and probably pass an order. I think Justice Kurian will be able to advise us on that. I, for one, would feel that if the Supreme Court had made a recommendation of an act or a legislation to be brought in, then the Supreme Court will within its jurisdiction under 142 to say, my dear government, please tell me where is that act and what have you to say about it. And it's time that we must question that. That is where we'll be able to bring synergy into all stakeholders. That's where everybody will, as you rightly said, everybody will then collaborate. We will all know what our stakes are. Here, what we find is A does something, B goes and does something wrong on the totally other side. So we need to stop that in this country. We need to bring together each one of us who has a stakeholder. And therefore, that is the important part today. And therefore, we must develop those people. Many of us feel that I don't need the basic knowledge of law. That's a different question. I'm not debating on that to be a mediator or not. But if I don't have, then how do I going to write those settlements that are going to be a decree in the court? Therefore, I need to bring that concept of co-mediator, at least of a lawyer who knows the subject matter. And today we have brought this even in the Income Tax Act, that I can go to the government and go and say, I want to resolve with you. Now, if the mediation process is not recognized there, then how will that settlement really go through? Therefore, the question today is all those legislations must bring all stakeholders together to see how do we make this system a uniform system. As it is, there will be cultural differences between North and South India. That's a different question. I'm not raising that issue at all. That should be also recognized in the Mediation Act. But I'm not saying the process may change. I mean, I'm a mediator for a matter which is commercial. I may have a different approach altogether than a matrimonial matter or another mediator to do. But that doesn't mean the basic structure of the mediation will go away. The basic structure will remain there. That's all. And in India, we have brought new things. In Delhi, we have examples where we had a divorced couple. We sent them back married from the center. So the legislation, that's a process that we have to learn. That's where you need the training of mediators in the profession to come up to something innovative. And in this country, innovation, we have absolutely tremendous talent in this country. We just need to utilize it properly. That's all.
Sanjay, you actually laid the foundation for my next question, actually, which is, thank you so much for that. So, if you look at the bill, it talks about, accreditation of mediators being provided by mediation service providers. Now, so the question then comes is, do we need one standard sort of an accreditation? And this in light of who a mediator is. While the act as a mediator is anybody the parties appoint and includes an accredited mediator. So it doesn't have to be that a mediator has to be somebody who's accredited. But when we talk about you being an accredited mediator, it says the service providers are free to provide such accreditation. So is it a good idea to have one standard of a mediation training service, which, you have service providers who provide that, and it's like a common syllabus? Or do you have it like the market forces decide and you have multiple forms of the trainings provided, and each service provider has a right to give an accreditation once it is authorized by the council again to provide such a thing? I know this is a debatable point, but it'll be good to just hear your views on this. Mr. Chandra, since you raised the point at the base, we can start with you.
He's saying, today, first submission is that you should see who are the mediators today. Give them time to look at it, lay down some regulations for them to look at. If they comply with it, otherwise the training, obviously they have done their training. It's not that they have become mediators from the childhood of they have gone through, the process has gone through for years today. I mean, can somebody today even raise a figure to say Shriram Panchu is not a mediator? I mean, it will be foolish on my part to even say that. Or can I say that today, all those people who have done mediation have brought this process to this level? And in fact, it's a people's movement. Let's be clear about it. It is people who decided that we must resolve our disputes, taking the aid of a mediator to see how best we can resolve it. The pandemic has shown us this, especially with MSMEs. There's a Development Act, there's other acts which are talking about, but the system is different. So if the statute has to come, then you're looking at a mediator, you must look at what is he going to do today. Today, you could have said anybody who has done mediation training with a, and we have, as Shriram Panchu has rightly said, you have actually court annexed mediation has been thrown out. So if it has thrown out all those mediators who have been trained in the court annexed mediation or goes out, then he can't get recognition. He's not a mediator then. Then how? And most important part, I think the Legal Services Authorities Act has to be thrown out of, excuse my using this expression. It has nothing to do with this. Its purpose is to provide legal aid to people. It can't be an authority to administer Mediation Act. We must keep it aside. But we want to keep that system different. I'm saying you must bring a system where professionals must think about themselves, professionals must think about regulating themselves, professionals must think what kind of training should they do. And with changing economic times or laws, we may have to change our training programs also. And I think Mr. Francis already right that if I am a trainer and I'm a mediator, all right, but if I don't know income tax law, I'll probably bring a mediator who has done training with income tax and bring him on with me as a co-mediator to help me do that. But that collaborative process is not starting. We are starting on a note as if we must include ourselves only. That has to go, and we have to bring everybody together if actually the concept of mediation has to go through in this country. Because that every citizen of this country must learn the way of life. Mediation is a way of life. You have to treat that as a way of life. How do you resolve? Whether it's small kids, we have seen going now for training in schools, we find how children get responsive to it, how people in the universities have responded to it. So therefore, we are now looking at people, they should have a way of life to see that I'm not going to look at somebody, Mr. Chandok, and say I'm going to have a conflict with them. I want to resolve it. And if that is the situation, then I think time has come when the very purpose of bringing this concept of mediation into this country, into the lifeline of this country, must be adopted, what actually mediation means in actual practical life.
Mr. Panchu, over to you now for your views on this.
You just spoke up one of my big fears. We don't know what these people are going to sit there and say, oh, this is the pass mark for mediator training. Over the years, we have suffered with something called a 40-hour course.
Right.
As though that was the 11th commandment. You didn't do the 40-hour course, no way you can get in over here. And even when I tell people, look, this guy's gone to Harvard, Stanford, done a training over there in Singapore or Pepperdine. No, but has he done the MCPC 40-hour course? So these are the kind of potential disasters in the making when you don't have some sensible mediator sitting on this council. Anyway, I'm hoping that things don't come to that pass. You see, because I have seen training abroad where there are no separate sessions. All the time, the mediator is with the parties and their lawyers. They do not break into separate sessions. Now, for me, it's kind of gospel that, you get into separate sessions because that's where you can talk to them about their fears, their concerns, the options of settlement. So there are schools of mediation thought which don't do that. And which just operate everybody together. So, we need the recognition that mediation is something which can be gloriously unstructured. because it's essentially a humane process dealing with people in a very humane way. But that needs to be understood. You know, that core base of integrity, we wanting to do well in a mediation, the capacity to earn trust, those are at the core. You must have them. But building on them, you know, the methodology, you don't get scriptural for that. Get good people, you know, make sure they have the basics, and they'll develop. You know, mediation is not like practicing, you know, surgery where you have to get it within that 1 inch and do this, you know, this meter at this time, etc. It's not engineering, it's nothing else. It's a very human process. And one has to realize that to a litigant, essentially, what does that litigant need? And in, yeah.
Thank you so much. So my last question, and that's to Justice Kurian and Francis. And this is to Singapore Convention and Part 3. Government, as we all know, is the largest litigator, you know, especially wherever you look at it. And strangely, for Part 3, the government has excluded itself from the purview of international commercial mediation when it comes to under the Singapore Convention. A quick thought of in Justice Kurian, what do you think about it? You know, is it fair? Because again, you know, the government wears multiple hats. One is as it is as a commercial party to a dispute, and the other one, of course, it has its sovereign functions. So how do you view this exclusion by the government? And Francis, you know, in view of your experience with Singapore, is the government excluded from the applicability of the Singapore Convention? Has it excluded itself? And have you come across any governments who have actually played a role where they say that, you know, even if we enter into a mediated settlement agreement, it will not form part of the Singapore Convention? And Justice Kurian, and then we'll go with Francis.
Yeah, before I move on to answer this question, let me say one way to salvage the situation is, instead of testing its validity on the before the court on the judicial side, I think as Mr. Chandyo rightly said, the people who made the bill should tell the government that, what happened to the one whom what we made. If you have to correct it, just get back to us and let us also know why you want to correct it or want to deviate from it. So a joint, as this is Mr. Panju's point also, according to me, the duty holders and stakeholders both should sit together and work out a bill before it goes to the floor of the parliament. Otherwise, the type of discussions that will take place on the floor will be different, and it will be tested on the judicial side. It will be a disaster. It's the same that was used. And coming to the exclusion of the government, see, as far as India is concerned, if you take the commercial disputes, it's not as if the government was never into commercial activities now. 50% of their activities are, according to me, if not more, are commercial only. Therefore, the type of treaty, the type of contract, the type of the works that they award, the service sector, the construction sector, all sectors, it's all outsourced and things, either outsourced, directly involved also into different government-owned companies also. So to exclude them, see the mediation, the preamble, the bill preamble says in the wide range. What is the wide range without this wide government, without not included? If not the government is not there, it becomes a simple process where petty disputes of this nature, and the government will continue to be the biggest litigant in the country. If you see the large number of cases in which commercial the government stakes are also involved, I will not agree that they should be included. And there are processes in the government also that in the process of mediation, they can take it to the policy decisions also. So that, the type of the status that they will have for a settlement on a floor of a mediation platform will have its own legitimacy. They're all upright now. To allay this fear, then it's better to include them and take it forward, helping them to take appropriate decisions at the appropriate stage also. That's also possible in mediation. So it should be inclusive and not exclusive.
Francis, your take.
Yeah, thank you, Ekta. I want to quickly loop back to your earlier question and briefly just add a perspective on how the Act, the legislation, can actually help accreditation of mediators. In a Singapore experience, it's opt-in. So mediations happen and then parties can, by consent, apply to have it recorded as an order of court. This process is then recognized as being open to recognized bodies and recognized mediators. So an example, SIMC, the WIPO Mediation and Arbitration Center, the Tripartite Alliance for Dispute Management, and then CME certified mediation or mediators. On this CME point, the progression is, in order to be a CME mediator, you have to go for an accreditation. It involves the 40 hours that was alluded to earlier. And then that entitles you to be level 1. There are 2 other levels, and the last level is a certified mediator. So the legislation recognizes institutions and the training received by a mediator. And I think this is a nice way of raising the profile. For example, I am a principal mediator with the SMC, so I qualify under the SMC box. I am an ambassador of the SIMC and a specialist mediator there, so I qualify under the second box of SIMC. And if I miss all those other boxes, I am a CME certified mediator, which is level 4. And so I am also in that box. But you see, the impression created immediately is when a party is having a mediation with that institution or that body, they make the connection back to the legislation and say, aha, this is someone has been trained, has the necessary standards, governed by the rules of the institutions of a certain standing, must be okay, and the process is recognized by the courts. So perhaps this is a way of, to use the word, harmonizing the legislation with the need to professionalize the individuals. Now, to your question, yes, our government has made themselves bound by both the Mediation Act 2017 and the Singapore Convention on Mediation Act. So the Mediation Act is Section 5, and Section 3(4) of the Singapore Convention on Mediation Act says this act binds the government. To the point of activity, the government, through its statutory boards and government-related companies, are probably one of the most active users of mediation. If you think of it, it's beneficial because when a dispute arises, they get to opt for mediation and keep the disputes confidential. So that means it's out of the newspapers, out of the limelight, and it gets resolved with the longer term relationships and the interests of the parties in mind. So yes, the government is a big proponent and user of mediation, and they are one of our most important stakeholders in the ecosystem. Thank you. Back to you.
Thank you so much, Francis. And thank you so much for the panelists. We'll just open it up for questions. So we have a couple of them. The first one is actually to Justice Kurian. In fact, this takes into how you look at matrimonial disputes. And they're saying that why is there no option for an enforceable prenup agreement? So while we're all talking about how we look at mediation in terms of a conflict, I think this is even pre-getting into an arrangement. So this is a pre-contract settlement agreement or a pre-contract prenup agreement. This question has been directed at you. So what would you say about it?
No, in fact, I not actually understood. I read that question. What is that prenuptial agreement between the parties?
So normally
Is a
it's matrimonial. So if you look at matrimonial, before parties enter into a marriage, they sign an agreement that in case they ever divorce or in case something else happens, then these are the terms of settlement as to what they would abide by. So it's not common in India, but it's common outside. Mr. Panchit, do you have something to add to this as well?
Well, that is what is known as a curveball being thrown to us.
No, actually, say the very basis of that relationship is not a simple contract. It is actually let God united, let man not put asunder. That is, so it's a covenant, not even a contract. It's a permanent covenant. Therefore, I do not believe in the once I take this shirt, suit, it doesn't. I like it. So after 2 years, let me change it. Why should I? Let me let me turn. So I don't think that if you're going to destabilize that institutional marriage, actually contemplating that there is a likelihood of a division, and in which case, we'll have 2 children, one for you, one for me. So that way, not one only. Can be such quixotic ideas for this sort of, except for this marriage, I say.
I think we'll give it to the law ministry. They can put it in Schedule 2.
But in India, sir, we have a Satpati, we have a Anand Marriage Act, which have nothing to do with the pre-contractual situations in marriage law. Therefore, we can't bring that concept here unless we change that part to bring that concept. Today, even all for that matter is all actually speaking is something to do with the religion part of it. And therefore, it is actually saying marriages in India are made by God and not to be created by us contractually. Therefore, probably there can't be an agreement prior to that. But the judicial pronouncement Ekta has brought into us to say that if there is a disharmony or probably divorce, what will be divided between the parties today? There is a section under the Hindu Marriage Act, for example, which provides for it. What do we do about it? So it's not that it's without force. It's already there in the statute.
This is interesting actually. The idea in a prenup is to say, okay, if you're going to have problems, this is what will happen. So what's wrong in saying if we have problems, so and so is going to be the mediator?
Yeah.
That's a wonderful idea. In case there is a problems which we can't resolve between ourselves,
yeah,
we should go for we should resort to mediation first. Yeah, that's a mandatory mediation in the event of a matrimony.
So it brings us to the first question. Every dispute must go to mediation, whether matrimonial or otherwise. That brings us back there.
Krishna, I hope that answers your question. Yeah. The next question, it's from an anonymous attendee. It's like,
I think we should charge for that answer. It's expertise.
So they said, what do the panelists think about making mandatory online mediation for e-commerce? Now I'll just add a twist, because if you look at the bill, it talks about mandatory pre-litigation mediation. But when you look at e-commerce, the platform is entirely online. So this, I think, talks about when you look at ODR, and a lot of e-commerce things not necessarily get into court at all because the values are so small. So you usually have a frustrated customer or a consumer, which never really gets into a dispute scenario. So in that context, how do you look at online mediation for e-commerce and making that mandatory, irrespective of whether there is a dispute going to court or not? We can go with Mr. Pancho and then Mr. Jandyok. Anybody?
Correct. Because normally speaking, Amazon today, you don't want something, you give it back to them. At the end of the matter, where is the dispute? They'll credit your account. So dispute only will come in. Therefore, the questions are in India today on ODR. We are finding confidentiality. Maybe is a question that we need to address ourselves to be. But yes, to our mind, at least I think we all are probably on the same page to say that every conflict of whatever nature, small or big, must go to a mediation. We must make an effort to bring peace, resolve, settle the parties to do it. And therefore, it's the mediator who will be able to know what is the underlying interest, even whether it's a matrimonial or it's an online dispute. He'll be able to understand what is the problem. And therefore, he'll be entitled to empower the parties to see what is the best settlement that they can have. But most of the time, find that most of the things, if I don't want something from Amazon, I'm entitled to return it. But many times, of course, there can be a dispute. I still find there are disputes coming with respect to that. But there's, as you rightly said, the amount is so meager that probably it will not go to, it won't be, I just Korean will remember, we had a case coming from Allahabad High Court, which the person said, my mother was legally wedded to my father, and therefore I'm entitled to have the estate. Till in the Supreme Court, we were able to show that if this mother was married, she was only 5 years old. So how could she be married? No court has seen this position. So this is an adjudicatory process which has been a problem. But if such a problem would have come to a mediator, he would have himself seen and told them, felicitated them that, how are you seeking this right in the estate if your mother was 4 years old when you are talking about the date that the marriage took place. So therefore, all those questions will be resolved better to the satisfaction of the society rather than adjudicatory process.
So the next question, in fact, is on, when you're talking about, so Ajanta has a question on, when you look at time frame for mediation, can you have a single time frame given for mediation? So if you typically look at, it says, if you look at the mediation bill also, it says the mediation shall be concluded within a particular period of time. If you look at even, court annex mediation or NCLT, there's time frames again involved. So, how do you view that? Can you say that this is the time required for a particular kind of a mediation?
The time now proposed is 90 days, it can go to 180 days. I think that's the time now proposed in the bill. But in the event of not prescribing a time limit at all, I think, one of the parties, if they're an interested party, they will simply keep on dragging. So I think better to prescribe some time limit for the mediation. And if they want it beyond that time limit, as we have in the Arbitration Act also, we can go to the court and get it extended or something. Otherwise, the party should agree for extension of time. That's something like that. So better to have a time frame so that the parties will also have that seriousness that we need to have a time-bound solution as well. But there may be situations which some disputes may not be in a position to be resolved time-bound, which may require longer time. Of course, it's a party autonomy, definitely. As in arbitration also, is a complete party autonomy in mediation also. Therefore, I don't think there's any problem for extension of time. But better to prescribe a time limit to start with.
Yeah, I think that having a rigid timeline doesn't work well. I mediated disputes, some have taken more than a year, one took 17 months. So to say, full stop after 90 plus 90 doesn't work well. At the same time, I see Justice Kullian's point that, don't leave it completely loose, that, people will lose track of it. So I think the best way is to say that, of course, you can have periods beyond 180 days, but both parties must, give something in writing to that effect. They must apply their minds and give something in writing to that effect. And then it can be open because, frankly, this is all, pre-litigation. And it's party autonomy. And if one party thinks the other party is just wasting time, you just pull out of the mediation. So something, make sure it's on track, but certainly not a rigid depth.
The last question actually is by a couple of people, and this is actually tying in with the discussions we had earlier when we talked about, when you have complexities in a mediation, and you have the concept which Francis mentioned about you have co-mediation. So a couple of people are actually talking about that they're non-lawyers, but they want to look at mediation. So is it something that is worth pursuing? Francis, what would you say to this?
We have
non-lawyer mediator.
Understand. So maybe I'll frame it in a different way. Is a law degree or knowledge of the law a prerequisite to being a mediator? Well, the Singapore experience is that no, you can have mediators from all walks of life, all backgrounds and all training. Of course, knowledge of the law may be advantageous because you have an understanding of what's perhaps workable and fair in a certain circumstance, but not necessarily the best. So, for example, in the construction sector, we have some quantity surveyors, architects who have also qualified as mediators. So they bring their unique skill set, and if they have that prerequisite underlying of approachability and being able to communicate and facilitate the communication of parties, he can qualify as a mediator if he goes through the requisite training and get accredited with the CME accrediting system. So that's the experience of Singapore.
Thank you. Thank you so much, all of you, for a wonderful discussion on the mediation bill, the hopes and concerns. I'd like to call upon Mr. Puneet Jindal, who will give the vote of thanks on behalf of CMC and WebNyay. Mr. Puneet Jindal is a reputed and well-known senior advocate practicing in the Punjab and Haryana High Court and other courts and tribunals in Chandigarh. He has been practicing for more than 35 years and specializes in arbitration, constitutional matters, property disputes, electricity and energy disputes, and service matters, amongst others. He has represented the Government of India in numerous businesses and organizations, both international and domestic, in litigation and alternate dispute resolution. He is passionate about technology and access to justice and is an advisor to the founding team of WebNyay. Mr. Puneet Jindal, over to you.
Thank you, Ekta. On behalf of organizers, WebNyay and Center for Mediation, Bombay Chamber of Commerce, I would like to thank Justice Kurian Joseph for sparing precious time and enlightening us so much. My senior colleagues from the bar, Shri Ram Panchu ji, Amarjit Chandok ji, for their valuable time. I'm expressing my thanks from the core of my heart to Mr. Francis Go for for sharing his valuable experience from Singapore. And we can certainly adopt most of the practices and hopefully we can improve upon them also. And most importantly, Ekta Bahalji for moderating the session. Well, as we have seen with the passage of time, while we have faced this pandemic and other problems, we have, at least we being a part of judiciary, we have seen a very quick and adaptive judiciary. They have adopted video conferencing just from the onset of pandemic itself for daily hearings. Over the past more than 18 months, thousands and thousands of hearings have been held by courts across the length and breadth of the country, and cases disposed of online. Of course, also some cases offline also, but mostly online. It's time we should keep momentum going on, not only for the courts, but also for mediation and arbitration if possible, which is very much now the practical and possible. Globally, justice delivery system all over the world have embraced integration of technology, and we looking forward for that. Due to this, justice is now no longer associated with a place like courts, as very rightly pointed out by Justice Kurian Joseph, that seat of arbitration or seat of mediation now loses its significance altogether. We used to say that we need to deliver justice at the doorsteps of the litigant, but now we are taking the justice delivery system to their rooms, bedrooms and drawing rooms as well, through online dispute resolution. I believe mediation, if correctly used, can drastically reduce pendency of litigation, as our judicial system is heavily overburdened, causing a traffic jam like situation. And we can create waves in increasing access to justice. I would just add one point, if as has been pointed out by Justice Kurian Joseph, that why exclude government? Well, I have a suggestion. Not only the government should be a part of the mediation process, but just like the RTI, Right to Information Act, they have appointed a PIO, Public Information Officer, in each department and organization. In the same manner, the government can appoint one person who is authorized to participate in such mediation process, when is such required, and he is authorized to settle the dispute on behalf of the commercial organization or department. So I believe that it's a very valuable suggestion of Justice Kuring Joseph, and with procedural what I have suggested, I mean something more that can be added to it. We must take mediation and mediators to the people's place, and mediation bill does talk about online mediation, and online mediation will certainly strengthen our further support to these practices for this resolution of disputes of all sorts, including government bodies and government organization and government departments, apart from commercial and family disputes, as we were discussing. Some of you might be aware that Niti Aayog committee, headed by Honorable Mr. Justice A.K. Sikri, they have recently published a policy plan for adoption of ODR, Online Dispute Resolution Platform. And the committee believes that ODR can help in promotion of legal health in the country, even when the pandemic is over. The avoidance and containment of disputes, the resolution of those disputes that knock the doors of the judiciary, all these things, the online dispute resolution system will be a great help. In some regard, organizers are the leaders in this space. The CMC, the Bombay Chamber of Commerce, is an independent mediation center with world-class mediators. WebNyAI, on the other hand, provides a world-class technology, so mediation hearings can be conducted online and settlement agreements signed quickly and effortlessly. Online mediation can also be used to resolve dispute under the Consumer Protection Act for all e-commerce transactions and other trade-related disputes. MSMEs can also benefit from online mediation and WebNyAI's technology. Finally, CMC and WebNyAI are planning advanced workshops, trainings, and certificate courses for mediators, lawyers, and other professionals that want to become mediators. This online consultation was just the beginning. CMC and WebNyAI have an exciting lineup of events planned for mediation enthusiasts. Watch for that. Thank you very much.
Thank you, Puneet. Thank you.
Thank you.
Thank you. Thank you, Ekta ma'am, for a wonderful session.
Thank you, Mr. Khosa, for this opportunity, and thank you so much for all the participants want to attend the session, and to the panelists for your wonderful insights.
Normally, I will just add one thing. One disadvantage I would say about the online, I would have invited all of you for a dinner or a cup of tea, which I am not able to do now.
You can take a rain check.
Yeah.
Sure. Thank you.
Okay,
Thank you.
bye. Bye. Bye-bye.
Thank you.
Thank you.
Thank
Thank you, Justice.
Thank you, Sridham. Thank you, Mr. Francis. Thank you, Chandyok,
Thank you, my lord.
Bye-bye.
Thank you, everybody. Thank you, Ekta.
Puneet, and everybody. Yeah.
Everyone.
Thank you. God bless you. God bless you. Stay blessed.
Thank you.